Bismillahir Rahmanir Rahim. Assalamu alaikum wa rahmatullahi wa barakatuh. Ladies and gentlemen, especially the students in the Faculty of Business and Economics in the current 5th semester, welcome once again to our session of Introduction to Business Law. And today we are going to discuss about the second part of our session, which is about the contract of sale. Previously we had discussed about the law of contract, which actually we said that it is the most fundamental part, because any other mercantile activities, any activities of any business, they are centered around the law of contract. And today we are going to look into the contract of sale as earlier projected. And when we talk about a contract of sale, we say that a contract where the seller transfers or agrees to transfer the property in books to the buyer for a certain price is called contract of sale. Meaning that you as a seller, if you agree that you are going to transfer the things that you are selling in your shop or in your business to a buyer, then the buyer is going to pay you a particular price for those goods or those things. Then it is what we refer to as a contract of sale. Take an example. You have your small business. Maybe you're selling electronics appliances, or maybe you're selling you're having a boutique shop selling clothes and many other things. Then somebody comes to your shop and wants to buy a good from your shop. So the moment you agree to give that person that particular good, and that person is going to pay for that particular good a certain price, then it is what we refer to as a contract of sale. The contract of sale is generally of two types, namely the sale and agreement to sell. We have to note the difference between the two. Executed contract of sale is called sale, and if contract of sale is to be executed in the future, then it is called agreement to sell. So the moment somebody comes to your shop, agrees to buy a particular product or good, and immediately pays for that particular good or product, that is what we refer to as sell, as in S-A-L-E. However, if somebody comes to your shop and then gets the goods or materials from your shop, but the payment is to be done sometime in the future. Maybe the person says, give me one mobile phone from your shop and then I will pay sometime in the future. That is what we refer to as agreement to sell. Why? Because the contract of sale is to be executed in the future. The sale that which we are using here is S-E-L-L. So when we talk about the contract of sale, generally we have two types. That is sale, which is executed contract. Somebody comes, buys and pays for the product and takes the product and goes away. And agreement to sell, which actually somebody comes, takes the product or takes the goods and then promises to pay sometimes in the future. So if it is sell, then it is okay. Business is going on as usual or as planned. If somebody comes to your shop and then buys goods or materials and immediately pays for that particular good, then there we have no problem. It means business is going on well. But sometimes problem comes when we have agreement to sell, because sometimes you find somebody comes to your shop, takes a particular good, and then the payment is to be made in the future. However, problems might come from there because somebody might fail to pay according to the agreement that which has been made. Now, in the case of agreement to sell, if we have such a problem where the seller, the buyer is not capable to pay for what has been agreed upon. What is going to happen next? We have the rights of unpaid seller. The seller who has not received price of goods sold, or the seller who has got his negotiable instrument dishonored, will become unpaid seller. And the rights of unpaid seller can be classified into two groups, that is, rights against the goods and rights against the buyer. So the seller, if at all he has not received the price for the goods sold, then it means that he is unpaid seller, meaning that somebody has come to his business or her business, taken some goods, but has not paid for those particular goods. So at this moment, the seller is unpaid. What are some of the rights that which the seller has? If somebody takes goods from your shop or your business, and the person has not paid for that particular good, you have the right against the good itself, and also you have the right against the buyer, the person who has actually taken the goods from your business. And what are the rights of unpaid seller against the goods? When goods are in existence and title has not yet gone to the buyer, unpaid seller can exercise the rights against the goods. These rights are categorized into three types, which are right of lien, right of stoppage in transit, and right to resell. So when goods are still in your business premises, maybe they are still in your shop, and the person has not yet taken those particular goods. However, he has promised that he's coming to take, or he's going to take at some particular moment, and then will make the payment in the future. So at this moment, the seller is an unpaid seller, can exercise some rights or can practice some things against the good. These rights we have are referred to as right of lien, right of stoppage in transit, and right to resell. The right of lien, right to retain goods by unpaid seller till amount is recovered, is what we call right of lien. So you can decide as a seller not to give the goods to the buyer. You can decide to keep the goods at your shop or at your premises until the buyer pays the money. Once the buyer pays the money, then you can be able to release the goods, and then the title can be transferred to the buyer. However, you as a seller, if somebody has not yet paid for the goods, you have the right to retain those goods, keep those goods until the amount is recovered. That is what we refer to as the right of lien. Another right we have is right of stoppage in transit. Unpaid seller has right to stop the goods in the transit itself. Transit here we are talking about is movement of goods from one point to another point. At this particular moment, we are talking about movement of goods from the seller's premises to the buyer's premises or the buyer's possession. So you as unpaid seller, in case the buyer has not yet paid for the goods, you have the right to stop the goods while they are in the transit itself, while the goods are still moving on the way. Take an example. Maybe you have purchased goods from, let's say maybe you have purchased goods from Hargeisa, and your shop is in Bur'o. The seller is in Hargeisa and the buyer is in Bur'o, and the buyer maybe says, please transport for me those goods, let them move, and bring them to my shop or my premises in Bur'o. So while the goods are still in the transit, in movement from Hargeisa to Bur'o, in the middle of the way, the seller has a right, can decide to stop the movement of these goods to the buyer and return them to the seller's premises until the price of the goods is met. So the seller, the unpaid seller, has the right to stop the goods from reaching the buyer in case the buyer has not yet completed the payment of those particular goods. Another right is the right to resell. The unpaid seller can resell the goods for non-payment of price by buyer. He can exercise this right when the goods are of perishable nature. While doing so, it is beneficiary to the seller to give a notice to buyer with regard to resale. So sometimes you as a buyer, if somebody, maybe you are dealing with perishable goods or perishable products, for example, flowers, natural flowers, or maybe tomatoes, those goods which actually can get spoiled easily or can expire easily in a very quick way. So what do? You as a seller, in case you are dealing with perishable goods and the buyer has not yet paid for those particular goods, you can resell those goods to another buyer. However, we are saying that while doing so, it is beneficiary to the seller to give a notice to buyer with regard to resale, because you have to tell the buyer that, oh, my friend, the goods you had purchased previously, actually the time is going, you have not yet collected the goods and they are perishable. They are going to actually expire. If you don't collect them now, by tomorrow they will be expire and you will be making losses. So what if I sell it to another person? Yani you have to inquire, you have to inform, give notice to the buyer that you are going to resell those goods to another person, so that it cannot bring some problem again in the future. Because if you don't give notice to the buyer, then it means that the buyer can sue you, can take you to the court, and actually you can end up again paying some compensation to him. So that's why we said that you have to give notice to the buyer with regard to resell. So you as a seller, unpaid seller, another right that you have is the right to resell those goods, and you have to make sure that those goods are of perishable nature, and while doing so you have to make sure that you give notice to the buyer himself. So those are the three major rights of unpaid seller against the goods themselves. Either you have the right of lien, which means that you're going to possess, to retain those goods until the payment is made. Then the right of stoppage in transit, which means that you can stop the goods from reaching the buyer while they're still on the way. And also the right to resell, and you have to make sure that these goods that which you are reselling, they are of perishable nature, and you have to give information to the buyer about the resale. What are the rights of unpaid seller against the buyer? At times, it becomes inevitable choice to exercise rights on buyer for non-payment of price. The unpaid seller can file suits against the buyer as explained next. So you as an unpaid seller, there are also some rights that you can have or you have against the buyer. Some actions you can take against the buyer. So what are some of these actions? Number one is right to sue for price. You can take the buyer to the court and sue the buyer to pay the price for the goods. Yeah, it is fundamental right of buyer to file a suit for recovery of unpaid price. In case of sale, suit will be made for price balance, but not for compensation. So you as unpaid seller, if somebody has not paid for your goods, you can go to the court and report the matter to the authorities. Then the authorities will take the step, and you as an unpaid seller, you can sue for the price of the goods that which has not yet been paid. However, we say that here the suit will be made only for the price balance. If it is in the case of sale, maybe somebody came, your phone costs $100. Somebody came and paid $50, then the balance is $50. So if that balance of $50 has not yet been paid, you can decide to sue for that particular price. So the suit that which will be made will be only for the balance and not for compensation. Nothing extra has to be paid for that. Another action or another right that a seller has is the right to sue to interest. If the buyer makes unreasonable delay for making payment, the seller has right to claim interest also. However, this also depends in the situation. For example, basing on Somaliland context. According to Somaliland context, we are a Muslim nation. In a Muslim nation, Islam does not allow interest on goods. So, if the buyer makes unreasonable delay for making payments, there is some extra charge, extra payment that which this buyer will have to actually pay to the seller. That is what we refer to as interest. So the seller also has this particular right. However, basing on our Somaliland context, according to the Islamic teaching, interest is actually something that is not allowed, meaning that you as a seller, you cannot sue for interest basing on our context. Another right the unpaid seller has is the right to sue for compensation. When an agreement to sell is breached, the seller can sue only for compensation for the breach of contract. Under such circumstances, he cannot sue for price. So sometimes you can decide to go ahead and sue the buyer for compensation and not for the price of the goods, because according to the right number one we talked about was the right to sue for price. There you sue only for the price and not for compensation. But here you sue only for compensation and not for the price of the goods. So this is also another important right that which unpaid seller has against the buyer. Another right is the right to sue for anticipatory contract. When an agreement to sell is breached by buyer before date of performance, it is called anticipatory breach. Then also the seller can sue for compensation. So sometimes, like we have said earlier, that under the contract of sale we have two major types of sale. That is the executed contract of sale, which is regarded as sale, and the contract of sale which is to be executed sometime in the future, which is regarded as agreement to sell. So in case of an agreement to sell, that is the person has promised to pay the money sometimes in the future. If this kind of an agreement is breached by the buyer before the date of performance, then it is called anticipatory breach. Maybe the person comes again and says that, oh, I will not be able to buy that particular product at some time in the future. So at that particular moment, you unpaid seller, you can also sue the buyer for compensation so that he can pay for the time wasted. Maybe you use some airtime to contact him, to call him, use some internet for doing some 2-3 activities about his goods and many other things. So he has to pay for that compensation. So in case of such a breach, then the unpaid seller has the right to sue for anticipatory contract. So those are the major rights that unpaid seller has against the goods. That is, against the buyer. That's the right to sue for price, right to sue for interest, right to sue for compensation, and right to sue for anticipatory contract. In all these, we have caveat emptor rule. While purchasing goods, buyer must be very careful at his own interest. Buyer has to select such goods only which are not of defective nature. In case where the buyer negligently purchases defective goods, he cannot repudiate the contract of sale. It is what we refer to as caveat emptor law. So you find sometimes in a situation whereby the buyer negligently purchases goods which are of defective in nature. Maybe you go to somebody's shop and then you buy a mobile phone that is not working. It is your right as a buyer to check the good before you purchase. Before you take any good from the seller, you have to check that it is according to what you need. You have to make sure that it is working properly. Or maybe you go to a shop, to the market to buy tomatoes, and then you find you yourself, you are seeing tomato. This tomato is spoiled. It's expired, but you take it and you take it to your home. It means that you have purchased that tomato negligently. You can see it with your eyes that these tomatoes are not fresh. They are expired, but you decided to take. So at this moment, you cannot return back to the seller and say that give me back my money. The seller at this moment is protected by a law, by a rule that we call caveat emptor rule. Take a good example we have here. For example, a case on this point is Ward versus Hobbs. In this case, a contract of sale gets formed between A and B, that is Ward and Hobbs, according to the terms of which A has to sell an animal from his farm to B. Negligently, B selects an animal which has been suffering from some sickness. That sickness is characterized by propagation from one animal to the other, and the ultimate effect is death of the animal. It should be noted that the sickness is externally visible. B negligently selects such animal, and as a result, all animals present in B's farm comes across death. B sues A. Court decides that B is negligent. He cannot blame the seller for his own negligence, and therefore B cannot claim any compensation. Thus, caveat emptor rule protects the seller. This rule is unfavorable to the buyer. In our example here, we have two people. One person has a farm. His farm has got some animals. However, one of the animals is suffering from a particular sickness. A sickness which actually can be transferred from one animal to another animal. And the end result of this sickness is the death of an animal. So, in the farm of this person, A, there was this one animal which was having the sickness. Then this person B goes to the farm of this person and says, Anige, I want to buy one of your animals. Then the person A says, okay, you select the animal that you want. Then this person B could see that this animal is sick, because there are some signs which actually are visible. That's why we are having here, we are saying here that it should be noted that the sickness is externally visible. It can be seen clearly. So this person could see clearly that this animal is not healthy, is sick. However, he goes ahead to buy that animal. Then he takes it to his farm. While taking it to his farm, reaching upon his farm, what happens? This animal transfers this sickness to his animals, and all his animals die. Then he goes to the court. The court says, no, you cannot sue person A. Why you cannot sue person A? Because you negligent. By negligent here, it means that ignorantly you just look and you say, you don't care about your selection. So you negligently selected a sick animal, and that is why we cannot approve your compensation. That means that the court has protected person A using the law we call caveat emptor rule. And that's why we say that caveat emptor rule protects the seller. This rule is unfavorable to the buyer. So, even though caveat emptor rule is there to protect the buyer, there are some circumstances where actually this cannot happen. We have some exceptions for caveat emptor rule. When caveat emptor rule is not applicable, the buyer can repudiate or can refuse the contract. The shelter of caveat emptor rule is not available to shelter on the following occasions. There are some situations where the seller cannot be protected or cannot be sheltered by the caveat emptor rule. What are some of these situations? Situation number one is when the sale is needed by means of a description. When goods are sold on the basis of description, the delivered goods must be in accordance with the description. If it is not so, seller's fraudulent behavior can be observed, and there is no ground to say that buyer is negligent. then caveat emptor rule is not applicable and buyer can repudiate the contract. Sometimes the buyer will come to your shop and says, I want to have this type of a product. Then the buyer gives the description of the good that he or she wants. At this moment, when the description is provided, you as a seller, you are supposed to obey the buyer's description. And you have to make sure that you give exactly what the buyer wants. For example, I come to your shop and I say, I need to buy a mobile phone which is Nokia in nature, and also it must have, let's say, a camera of 15 megapixel. It must also be having a memory of 64 GB and other descriptions I give. So you have to make sure that you give me exactly the good which I have described. Otherwise, if you give me another phone which is not of the nature that I want, then at that moment you cannot be protected by caveat emptor rule, because it will show that you as a seller, you are fraudulent, and therefore you have no right to be protected by that rule. So when the sale is needed by means of a description, there we have no way we can protect the seller using caveat emptor rule. Another one is when sale is made by means of a sample. When goods are sold on the basis of sample, the delivered goods must be in resemblance with the sample. Otherwise, the seller cannot claim the shelter of caveat emptor rule. So when the goods are sold on the basis of sample, somebody comes to your shop or your business and tells you that I would like to buy a product like this, comes with a sample of the product. Or maybe I come with a mobile phone and I tell you I need a mobile phone like this. Then automatically you as a seller, you have to make sure that you give me exactly the same sample, with the product with the sample which actually I have provided to you. Otherwise, if you don't provide according to the sample, then it means that you will not be protected by caveat emptor rule, because you have no basis to defend your decision. Another moment when a seller cannot be sheltered by caveat emptor rule is when purpose is mentioned. At the time of purchasing the goods, if buyer communicates the purpose for the sake of which he is purchasing the goods, seller should sell such goods only which are suitable to that purpose. Otherwise, caveat emptor rule is not applicable. So sometimes a buyer can come to your business and tells you that I would like to buy a good. The reason I am buying this particular good is because I want to do A, B, C, D with it. So you have to make sure that you provide that buyer with the good that which is going to serve his or her purpose. Otherwise, if you give him or her a good which is not going to help him to serve his purpose, then at that particular moment it's not going to work and you cannot be protected by caveat emptor rule. I come to your business and I tell you I need a cape which will help me protect me from direct heat from sunlight. So you have to give me a cape which will protect me from sunlight. Otherwise, if you give me a cape which is not going to cover my head, is not going to protect me from sunlight, then at that particular moment you're not giving me that good which is going to serve my purpose. So you as a seller, you have to make sure that when a buyer comes to your business and asks for a good and explains to you the purpose for that particular good, then you have to make sure that you do that. You're a pharmacist, I come to your pharmacy and I tell you that I'm feeling headache. I want you to give me medicine of reducing my headache or curing my headache. And then you give me a medicine which is going to cure my stomachache. You see, the medicine you're giving me and the purpose I've told you actually are not matching. Me, I need a medicine which is going to serve me from, it's going to cure me from headache. But you are giving me a medicine which is going to cure me from stomachache. You see, they are not matching. And therefore, you as a seller, you cannot be protected by such a caveat emptor rule. Another situation when such rule cannot protect the seller is when concealment is made. In case where the seller conceals or hides material facts and thus fraudulently sells goods, then also caveat emptor rule is not applicable. You as a seller, you are supposed to be open to your buyers. You're not supposed to hide facts. You're not supposed to conceal material facts. You're supposed to be open. If it is a mobile phone of 10 GB, you have to tell your buyer this mobile phone is 10 GB. Don't lie and say that this mobile phone is 60 GB, yet it is 10 GB. Don't hide the information. You have to be open and communicate well to your buyers. Otherwise, if you try to hide material facts, in fact, many sellers, because we are businessmen, we want to sell our products, we end up lying to our customers. A customer comes and we lie. Oh, this mobile phone is one of the best mobile phone. It is original, original phone. Yeah, the battery lasts 2 weeks without charging. So when you tell a customer such kind of information, automatically the customer will be interested to buy your product. But when the customer buys that product and actually goes and finds out that the information you gave and what actually is in the phone is totally different, at that moment it comes to be realized that you fraudulently sold your goods to that customer by lying to him or by hiding material facts, and as such it means that you cannot be protected by caveat emptor rule. Another situation is when misrepresentation is made. When seller sells the goods by giving misrepresentation, he cannot claim the protection of caveat emptor rule. Hence, the buyer can repudiate or can refuse the contract. So you as a seller, when you misrepresent a good, then you cannot be protected. Maybe Mr. Person A came to your business and then requested to buy a particular good and said, okay, I will send that good to you, and then you end up giving another particular good which actually is not what the person requested for. At this moment, you cannot be protected by caveat emptor rule, and as such you will be regarded as a fraudulent seller. So this brings us to the end of part 2. And part 2 we discussed about what you call the contract of sale. And under the contract of sale, we have said that there are 2 types of contract of sale. That is sale, which is executed contract of sale, and agreement to sell. Agreement to sell, we said it is a contract of sale which is to be executed in the future. And we have talked about this agreement of sale to sell, which is to be executed in the future, sometimes can have issues whereby maybe the buyer can fail to pay the price for the goods which actually have been purchased, and as such you as a seller, you are referred to as unpaid seller. We have looked into the rights of unpaid seller against the goods, and also the rights of unpaid seller against the buyer. Also, we have looked into caveat emptor rule, which is actually a rule which protects the seller from manipulation by the buyer. And we say that you as a buyer, you have to be very careful when you are purchasing goods. Don't go and purchase goods which are defective in nature and then later on come back and then return the book to the good to the seller and say that no, I don't want this good. You have to carefully select the good, because if you don't do that, then the caveat emptor rule will protect the seller, and you as a buyer, you will end up finding yourself in losses. Also, we have looked into the situations where caveat emptor rule actually cannot be able to shelter the seller. And up to there, it brings us to the end. And if you have any questions, please, you can just drop them on my WhatsApp number 063-427-1957. Thank you very much, and I wish you all the best.